You want to sue your doctor for medical malpractice, and you are comforted by the fact that the doctor has been sued before and lost. And you think that you can now use that information in your own medical malpractice case. Would you like to learn the real answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. You think a doctor violated the basic standards of medical care, and as a result of that, you suffered significant injury. And now you did some research and you find out that the doctor was sued in the past and lost at trial. And now you want to know, if you bring your lawsuit, can you use that information against the doctor at the time of trial? The short answer is no, you can't. The longer answer is you might be able to use some of that information at trial, but in all likelihood you won't be able to get out certain elements about what occurred in that past case. Now, why is that? Well, let me give you this example. Let's say you're driving down the highway and a police officer pulls you over for speeding. And now they go back and check your record, and it turns out that you were speeding 5 times in the same year, and you got tickets for each and every time you got pulled over. The mere fact that you had 5 prior speeding events, does that automatically mean that you were speeding at that particular time? The obvious answer is no, it doesn't. It clearly shows a pattern of your particular history, but it doesn't show that you were speeding at the time that the police officer now pulled you over. Well, the same exact logic is used in a malpractice case. Just because a doctor has been sued in the past, regardless of the outcome, that does not necessarily mean that he did something improper or departed from good and accepted care in your particular matter. We have an obligation to show to the jury that we are more likely right than wrong, that what occurred was in fact a violation from the standard of good medical care. If there is something that went on in the doctor's prior lawsuit that he lost that is somehow relatable to what occurred in your particular matter, in some instances, the court may allow us to use and go after the doctor when questioning the doctor. But in all likelihood, it's going to be very challenging and difficult to get the judge to allow us to now tell the jury what was the result in the prior case, and to be able to use that to try and convince the jury, hey, listen, if the doctor was responsible for those injuries and those harms that he caused to another patient, that obviously means that in this case it's the same thing. Well, that's not exactly true, and we're going to have a very tough and challenging time convincing the judge to allow us to get all that great information in. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding to what goes on in the litigation process here in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.